Well, welcome to this afternoon session where we're really focusing on the developments of freedom of conscience that really have arisen here in the state of Washington and state and federal courts here in our state. And my name is Bob Gomulkiewicz, and my interest in religious expression really goes back to my days as an undergraduate and a law student. I'm a product of the 1980s, and I spent some of my early days living in Latin America. And during the 1980s, there were great civil wars going on in Latin America. And refugees were flowing up here to the United States, and in particular to the Northwest. And I was very interested in a movement that was going on here in the Seattle area called the Sanctuary Movement. And you're going to hear some echoes of that movement here on the panel today. But that got me very interested in issues of freedom of conscience. And in fact, I was so interested in it that when I was getting my law degree here at the University of Washington, I also decided to get a master's in international studies from the Jackson School of International Studies, focused on the international protection of human rights. So I've been interested in this topic for a long, long time. But then my life took a different turn, and if you look at my biography, you'll see that I've been focused on software protection and intellectual property licensing. And but then our First Amendment professor, Stuart Jay, who retired a couple of years ago, went on sabbatical, and they sent out a notice to the faculty asking who would like to cover that class. And I just thought it was an amazing opportunity. First Amendment, the most interesting class to teach in law school. And so I thought, well, I'll just throw my hat in the ring because I have this long-standing interest in really the conversation about rights in the international sphere, international protection of human rights. And I would kind of pitch myself as a person who could bring that perspective. And indeed, that's the perspective you got from the first panel. And I'd never expected to get the assignment. And I showed up at the Associate Dean's office, and he immediately told me I could teach the class. I didn't even need to make my pitch. And what I found out is that no faculty member wants to take on that assignment. The material is enormous because I was proposing to not only teach freedom of speech, but also the Establishment Clause and the free exercise of religion. And so I got the assignment, and I've been teaching that class now for 7 years here at the University of Washington Law School. And it's just a joy for me to teach it every year because it's so interesting. And in fact, the discussion in this country is even more complex than the first panel was making it, if you can believe it. And as you heard from some of the conversation, there really are three parts of the discussion that you have to consider all at the same time. And you heard them articulated in the first panel, but I just want to identify them separately so you know how complicated it is. The first thing that's actually mentioned in our First Amendment is that Congress can make no law respecting the establishment of religion, whatever that means. And then it goes on to say that Congress shall make no law prohibiting the free exercise thereof, whatever prohibiting means. And then it goes on to talk about how Congress can't abridge the freedom of speech, respecting, prohibiting, abridging. Clear as clear can be, right? Well, no, it makes for a very interesting class, right? Because, in fact, what we have to do is we have to try to balance all of those values together in these questions, and it's very complicated. And so I think the conversation is complicated around the world, and you heard some of the complications already, and I find that conversation incredibly fascinating. And I think for those of us who live in the United States, it's important to understand that we're part of that international conversation. And so I'm really grateful that this particular symposium is bringing that perspective. But I also want to comment that just even in the United States, looking at our own First Amendment, it's an incredibly challenging discussion. I think it makes it a very interesting discussion. And as if that wasn't challenging enough, in this country, each state has its own constitution. And each state constitution also takes a position with respect to the establishment of religion, religious expression, and free speech. And that combination may be different than the combination that is embodied in our First Amendment. And so when we look at that, we know that these are even more complicated. And so that's why I think in some ways it's particularly apt that we're a panel here that's looking at things in the context of a state. Although some of the things that we're going to talk about are really in federal court and are federal issues, but some of the issues are really issues that involve the US Constitution, but also can invoke state constitutional provisions. The other thing I want to say about our particular panel is that there could not be any more interesting state to be having a conversation about freedom of conscience. And let me explain why that is so. Some people have described this state, in fact, one of my friends, Dr. Patricia Killen, has described the state of Washington as being a state in the none zone. And I don't mean N-U-N, I mean N-O-N-E. And where Dr. Killen gets that slogan is that when people fill out a census form and they're checking the box about what their religious affiliation is, that if you're in the Pacific Northwest, you are very likely, you're most likely to check none, no religious affiliation at all. And the most irreligious state in the Pacific Northwest is our state, the state of Washington. So you can predict that when I have an Establishment Clause conversation in my class, which is filled with lots of students from the state of Washington, you're going to discover that most of them don't affiliate with any particular religion, and in fact, are very skeptical of religious belief in some ways. That's on the one hand. On the other hand, though, Washington State is filled with, I would say, a diverse and thriving religious set of religious communities. And so I think that makes it very interesting here. And that has always been so. As you look at the history of the state of Washington and people moving out here with different religious traditions, it's always been a diverse place. But with the move of the tech industry here, with Microsoft in particular, you see people from all around the world, from China, from India, from Pakistan, from Africa, and as I'm naming off those countries, you should be thinking of all the religious traditions that are coming with that. Sikhs, Buddhists, Hindus, Muslims, Christians from Orthodox traditions. And so the fact that we have a thriving high-tech community here means that we also have a very active and diverse set of faith communities here. And so I think that makes the state of Washington a very interesting place to be studying these issues, maybe a particularly interesting place. And in fact, I live in Redmond, Washington, across the Lake Washington, and I live right next to a hill that they call Education Hill because there's so many high schools and middle schools and grade schools there. But if you drive on Education Hill in Redmond on a Sunday, it's Worship Hill. There are lots of established churches. There's a Catholic church and a Lutheran church and a Baptist church and a Pentecostal church. But what is more remarkable are these little churches that are meeting in every nook and cranny that they can find. And you can see their signs lined up all over Education Hill. So you can go to the Venture Church if you want. You can go to the Messiah Church if you want. And so Washington is such an interesting place because I think of this incredible diversity that we have. And I just want to tell you about one case that I find particularly interesting to just try to get you thinking, and then I'm going to turn it over to our panelists who are going to really occupy most of the time of our panel telling you about their developments. But a case that we've been talking about in my First Amendment class that I think that brings together so many of these issues is about a football coach. And of course, football is a religion, of course. Are any of you from the South? People from the South say football is a religion, but not just in the South. I grew up for part of my life in Eastern Washington, and in small towns in Eastern Washington, football can be a religion. But the particular issue there is about an assistant football coach, Mr. Kennedy. And Mr. Kennedy decided that after the football game, he would go to the middle of the field and he would kneel down and he would pray. And then over time, he invited students and others to come and join him as well. And Coach Kennedy lost his job over that. And that case is still being litigated and is moving its way up to the Ninth Circuit and may end up in the Supreme Court. I think that case is particularly interesting because of the conversations that we are having now in this country about kneeling for other reasons. Right. Every day that I pick up the newspaper, I read about a Seahawk player, Michael Bennett, and his kneeling before the game, and all the discussion that's going on around the country. So I just think it's a great time to be talking about kneeling for expressive reasons, especially in the state. And so with that, let me introduce our panelists, and we'll kick off, I think, a really robust discussion about developments that are local. And we're going to start off with Amy Williams-Derrry, and I would really ask you to look at the complete biographies of all these speakers because they're very impressive, but I don't want to take up all the time reading them, but I just want to point out that Amy is a senior member of the complex litigation group at Keller Rohrback, and when I read the kind of litigation that she does, it just makes my head hurt because I know how much work and how much intelligence it takes to litigate those cases. But for purposes of this panel, what's most relevant is that she is a cooperating attorney with the ACLU and is active in the Doe versus Trump case. And she's going to lead off. And then after that, we're going to have Aneelah Afzali, and she is executive director of the American Muslim Empowerment Network. And she's going to try to provide some social context for the Trump ban litigation that's going on. She may do more than that because she's also a lawyer, but the combination of Amy and Aneelah, I think, will be very powerful in helping us understand those issues. And then after that, we're going to hear from Jonathan Scruggs, who is a senior counsel and director of the Center for Conscious Initiatives with the Alliance for Defending Freedom. And he'll probably have a little bit more to say about the Masterpiece Cake case, but then he's also going to focus on a case that is from the state of Washington, the Arlene's Flowers case. And so with that, I'm going to turn it over to Amy.
Good afternoon. I'm very happy to be here, and I appreciate the opportunity to present to you today. I wanted to acknowledge the significance of this symposium today, and personally to me what it means, the ability to bring lots of different perspectives and groups together to talk about these issues, and I really appreciate that opportunity. My colleague Allison Gaffney is here today as well, and Allison helped me a lot in putting together materials, and she's co-counsel with me in our role as cooperating attorneys challenging the Muslim ban, the travel ban. You'll hear both names used. So thank you, Allison, for all your help. I am going to talk about our litigation, Doe v. Trump, which is pending here in federal court before Judge Rohrback. It's a case that's related to the state of Washington's action, Washington v. Trump. I'm going to spend most of my comments talking about that case, but I'm also going to talk just a little bit briefly about the Arlene's Flowers case and the Masterpiece Cake Shop case, because I'm a cooperating attorney with the ACLU, and the ACLU has been active in both of those cases. And so since I'm the only one here, I think, who maybe can offer a little bit of that perspective, I'm going to talk very briefly about those cases as well. But I would really love to get a sense of who you all are. I was expecting a lot of law students, and maybe the law student population has changed since I was in law school. But I suspect that we don't have. So do we have law students here? Do we have a few? 2, 3, a handful. Okay. And then others, are you, how about lawyers, practicing lawyers? The majority. Okay. And then any non-lawyers, non-law students, non-lawyers? Okay. And then for everyone who's here, then regardless of lawyer, student, non-lawyer, how many of you identify with a faith-based community? However, so almost everyone. Okay. Okay, thank you. Very, very helpful. Okay, so disclaimer also that these are my views. These are not the views of the ACLU. These are not the views of my law firm. These are my views. And feel free to ask me questions at the end when we get to that part of the presentation. Also, we have submitted some really interesting materials, which I believe you have access to online. I think you may have gotten an email about those. Let me just briefly describe them. I would encourage you to take a look at them if you haven't already. We have about 10 pages of case synopses, and we also have a timeline of the Muslim ban challenge, the litigation from January through this week, October, or the time when we submitted the materials. And so that tries to lay out some of it's so complex, all the litigation nationwide, but that will walk you through some of the key dates. We also submitted the joint declaration that was submitted early on in the litigation on the side of folks challenging the travel ban, a declaration by Madeleine Albright and other former national security and intelligence officials. And that a similar version of that declaration in opposition to the travel ban, saying it's not needed and not necessary for national security purposes. The travel ban has now been through 3 iterations, one referred to now as 1.0, 2.0, and 3.0. The third one due to go into effect next week. A similar declaration was just filed against the travel ban with 3.0, and that was filed by the state of Washington, I think on Thursday afternoon in federal court here in Washington. And then the last part of our materials are some local press coverage we've gotten about our case, Doe v. Trump. So let me, I appreciated Professor Gomulkiewicz's comments and talking a little bit about his background and his perspective, and I think that background and perspective is very important. And I want to tell you just a little bit about me. Who am I? I'm up here. I'm a cooperating attorney with the American Civil Liberties Union. You know almost nothing else about me, and you may have some assumptions or biases about me and about who I am. You might not, but I would assume you may. You may or may not have read my bio, but you don't have a lot of information about me other than my name, maybe a few of my professional interests or things I've worked on. So let me tell you a little bit about me, and then hopefully that will help you put in context the comments that I'm going to make. So I'm a litigator. I've been a litigator my whole career. At Keller Rohrback, I work on very complicated, complex, big cases. I prosecute class actions. I sue Wall Street. I sue Volkswagen. I sue opioid manufacturers. I look out for the little person, and I take on big challenges, and I go toe-to-toe with the biggest and most powerful law firms in the country, most of them in New York City. I travel like crazy. I've got more miles than I really would like on many airlines. And I'm an active advocate in federal courts around the country. And in fact, I would say I have more of a docket outside of Washington than I do in Washington. I feel like there was a time when the judges in the Southern District of New York knew me and my firm and the cases we brought fighting financial fraud, that those judges knew us better than the judges here in the Western District of Washington. So I've been really privileged to have that kind of a perspective on litigation. So the theme of my practice has definitely been to expose fraud and expose unfairness and to protect the vulnerable. That's how I would define it for myself. But I want to tell you a little bit more about me. So I'm also, like everyone, I think I have some outsider qualities, right? I'm a female in a male-dominated profession. It's a profession that's dominated by men, not only in terms of numbers and statistics, but also in terms of the norms and attitudes about litigation. So I'm an outsider. I'm also an outsider because I'm not from Seattle. I felt like an outsider in this city when I landed here. I'm from Boston. I grew up in the Northeast. And I wanted to tell you a little bit about that as well. This is a picture of my second grade class. And can you find me? I'll show you where I am in a minute. But when I grew up Irish Catholic in a suburb of Boston. And this is 1977, and this is my elementary school. And, let's see. Nope, there we go. Is that gonna work out? How about this? There I am. That's me. And the interesting thing I think about when I looked at this picture recently is I was I remarked on how incredibly non-diverse, at least based on skin tone, my second grade class was. I'm sure there was a lot of diversity, waiting to come out, but by skin tone, we were not a particularly diverse group. And it was really interesting to go back and look at this picture. And there's another person in this photo who you probably know, but you don't know, and that's Glenn Doherty down here. Glenn Doherty and I went to school together from second grade through high school. And Glenn Doherty went on to become a U.S. Navy SEAL, and he was working for a private security firm in Benghazi. He had retired from being a Navy SEAL, and he was serving as security for the U.S. Embassy in Libya when that awful terrorist attack happened, and he was killed in 2012. And so he was a classmate of mine and a friend of mine. And so here we are in second grade, and now, here are some stories. There are many more stories in this photo, but I'm focusing on these stories because when we get to our case, Doe v. Trump, it's filled with stories as well. And in our litigation challenging the travel ban, we represent half a dozen students and graduate students and refugees, individuals who were affected by the travel ban and whose personal and family and professional situations were put in peril because of the travel ban. And we also represent two institutions. We represent the Episcopal Diocese of Olympia, which is the Episcopal Church here in Seattle, which supports and runs a very active refugee program. And we also represent the Council on American Islamic Relations. So two institutions, half a dozen individuals. And each layer of that has all these stories, all these individual stories and backgrounds. And so let me take you quickly through the timeline. You might remember the inauguration of President Trump was in January 20th. A Friday later, January 27th, the travel ban came out, and came out on a Friday. And for those, what was really interesting to me about the timing of when that travel ban came out was, to me, it seemed like a real opportunity for those who were who were against it, who wanted to protest it, because it happened on a Friday night. It was one of the first things that had happened in this new administration, and actually it had been not at all first thing. That was quite a busy week, but people had all weekend to protest, and it really brought a lot of people together in unity against this thing that had happened. And you may remember here the 7 countries that were targeted by the travel ban, and you may recall the protests at the airport and the chaos that ensued. And this says. Let's see. Says no ban there, and this is SeaTac Airport on Friday, January 27th. So and then that Monday, the state of Washington filed its case. This clip here is from a few days later, but Washington, the state of Washington was the first state to file. There was an individual action filed by the ACLU in New York, I think on Saturday, and there was an initial TRO entered by a judge in New York in the Eastern District of New York. But then that Monday, Bob Ferguson and the state of Washington were the first state to file. And then I was on a flight that Sunday afternoon, so it was the 29th. I was going to Chicago for depositions, I think starting that next day, that Monday, and I was terrified about going. Here I am, Caucasian, blonde, Christian, affluent, educated, empowered. I was terrified walking into that airport. I took my passport with me. I'd never traveled with my passport before inside the U.S., and I thought, I don't know what's happening. I really felt like I needed to have my passport with me. I didn't know what the situation was going to be like flying that Sunday afternoon. Things had mostly calmed down by Sunday, but there were still some signs of what had happened over the weekend. Then a week later, I returned from Chicago midweek, and I made the decision to work as a cooperating attorney with the ACLU in challenging the travel ban here in Washington. And that Friday night, I think that was when I met Aneelah, I went to a forum, and I was talking with presented at a community group where Muslims were asking a lot of questions about the travel ban and implications for them. And I shared with them the story. They were asking, is it safe and what can I do? And my mother's here and I'm trying to go here and what about this? A lot of fear and concern, and also just a lot of questions about logistics. And I shared the story that I had brought my passport with me when I traveled to Chicago on Sunday, and the crowd just sort of chuckled. They couldn't believe, I think my interpretation of their body language was that they couldn't believe that someone who looks like me felt scared and grabbed her passport to fly to Chicago. And what it highlighted for me is how terrifying it must have been for immigrants and people of color and people who have fewer resources at their disposal than I do. So that was just a little personal story about that. We filed our case, the ACLU, we filed our case on in early February, and but before we filed our case, actually, Judge Rohrback issued a ruling in the state's case, and I was in the courtroom when he issued a TRO, a temporary restraining order, stopping the implementation of the ban, and there were so many people in the courthouse that day that they had an overflow room, and I was in the overflow room where we were watching it on video. Was anyone else there that day at the courthouse? And so Judge Rohrback, he heard argument, and then he read his ruling from the bench, and in the overflow room, the people burst into applause. It was really incredible, the tension and the energy there. And then we filed our case a few days later, but what we wanted to highlight in our case, which wasn't so evident in the state's case, was the impact of the action on refugees and immigrants. And ironically, EO1, Executive Order 1, in our view, had identified countries and people and regions that were dangerous and should be kept out. That seemed to us to be the purpose of EO1, or the implicit purpose, and yet there were lots of graduate students here at the University of Washington who had non-immigrant visa status to be here studying, and they were trapped in the country. They were from Iran, they were from Iraq, but they were trapped here because they couldn't, if they left, they wouldn't be able to come back and complete their studies. So it had this ironic impact of trapping people who were already here and who were here legally and lawfully and had been fully vetted, and not only were they no threat to our society, but they were here undertaking incredible and valuable research and pursuing advanced degrees, and they were trapped in. And so we have refugees who were here who had filed petitions trying to get the rest of the family to come and follow them, who and their family were frozen out. These are people who had passed security clearances and passed medical clearances and were just awaiting travel tickets. And you can't buy your own ticket when you're a refugee. You have to wait for the State Department to buy your ticket for you, and then you're told when you're leaving. So even if you happen to have access to resources to get yourself a ticket, you can't buy your own ticket. You're at the mercy of the State Department when they give you the ticket. And so these people were just waiting for that ticket, and then all of a sudden, the gate closed on them. So we were working with their, in this case, there were two men who were here, separate families, separate situations, whose wives and children were abroad and had been granted approval, but now couldn't come. But and I think for lawyers, this tweet really was difficult to take, because what I see in this tweet, when was Donald Trump shortly after Judge Rohrback issued the first TRO against the ban, the way I interpret this and my background and my perspective is that a lack of regard for the rule of law and a lack of regard for the independence of judges, and that was difficult to take. So you all remember and saw, I'm sure, a lot of photos like this, a lot of, one of the nice things that came out of, from my perspective, this past experience, it's ongoing still, but when you see signs such as "Refugees Welcome" or, just the images, a lot of powerful images. One thing I wanted to talk about briefly is our caption. On the left is our caption: John Doe, Jack Doe, Jason Doe, Joseph Doe, etc. v. Trump et al. And on this, so I guess that's your left, and on the right is a different caption. This is a caption for a case challenging the Muslim ban that was filed in Massachusetts. And you can see the petitioners there used their full names, their real names. We used pseudonyms in our case, and we did that for two reasons. Really, we had to, because our plaintiffs were terrified about their safety. And they weren't just terrified about, they were terrified about, violence on the street, violence from their neighbors for standing up and asserting these claims. They were worried about their employer, the university. They didn't know who might now think of them as unsafe or evil, and who might lash out against them. And there were some awful things happening in the news. There was shooting in Kansas and some awful things in Oregon, and so they were concerned about their safety, and they wanted to use a pseudonym. But for the first time in my lifetime, they wanted to use a pseudonym because they were afraid of retaliation from the government. That to me was really the scariest thing. I'm used to litigants being scared about reputational injury, or what will my employer think or my neighbor think, or if I step forward. But they were actually afraid that the U.S. government would retaliate against them. And when we talked about with the Justice Department, who's defending the case on the other side, we talked about with them the reason. There's a bit of a procedural step where we had to talk with them about why we were using pseudonyms. They didn't contest it at all. They said, we get it, we're not going to push back on this, we understand. So that was really shocking. I'm sure that I'm woefully over time, so let me just accelerate through the rest of these images. So the Episcopal Diocese, who's one of our clients, who runs the Refugee Resettlement Office, it's one of their ministries, and they see it as their obligation to fulfill their moral promise to welcome the stranger and protect the most vulnerable, and to reach out to people in need and to provide support and comfort. And they do that. They have 10 or more ministries in their parish, but one of their significant ones is the Refugee Resettlement Office, and they have about 10 full-time employees, and they have an office in the International District. And that's who we represented. And there's a success story. This is one of our clients, the gentleman in the photo. He's one of our Doe clients. And after the second executive order came out, we were able to successfully get his wife and children here. And so the family was reunited. And he had never met his son because he's Eritrean, and he had fled Eritrea. He was tortured and held in a prison camp, and he escaped, and he fled to Israel, and from Israel he fled to Sri Lanka, and in Sri Lanka he was imprisoned. And so when he was imprisoned in Eritrea for expressing his political beliefs, his wife was pregnant, and so he had met his daughter, but he had never met when he fled the torture and the prisons. His son wasn't yet born, and he left the country, and he'd been living in exile, and he finally came to the U.S. in 2015, never met his son, in frequent contact with his wife, and she had applied for refugee status. He filed paperwork to have her brought over, and one of the real highlights of my legal career was knowing that our work had some small role in helping them be reunited. So he did reunite with his family. He's Christian. He's not from one of the countries that's the subject of the ban, but the way the executive order was written, it prevented his family from getting here. And he tells stories about how he speaks 3, 4, 5 languages, including Arabic, and English, of course, and others, and Hebrew, I think. But he shared with us his stories about how he's frequently asked if he's Muslim. He works at a gas station. Well, his second job is working at a convenience store at a gas station. He's asked if he's Muslim. When he says he isn't, people also often confide in him, well, good, because I don't like Muslims. Or he's had people who are from this part of the world speak with him and say, do you speak, they'll say something in Arabic, hello or thank you, and then they'll say, we really shouldn't even be speaking in this language because other people will think negatively of us. And I know I'm over time. I'll leave you with just these slides. I won't say anything about it. This is a quote from the Arlene's Flowers case. This is the Washington Supreme Court. It said, this case is no more about access to flowers than civil rights cases in the 1960s were about access to sandwiches. Thank you.
Hello, everybody. My name is Aneelah Afzali, as Bob mentioned. Thank you for the introduction. Thank you, Amy, for sharing your words about sort of the work that you're doing. It's really inspiring to hear that. So I want to start by just saying that I am a proud American Muslim woman and recovering attorney. I firmly believe in God, family, and country, probably like most of the people in here based on the poll that Amy just did. And all of those aspects of my identity that I just described are really concerned and deeply sort of attacked at some level with what we are seeing happening right now with the Muslim bans, among other things. So I want to start by saying a few words and then really talking about the human impact of Muslim bans 1.0, 2.0, and 3.0, and really talk a little bit about some of the root causes as opposed to just the symptoms, because these bans are really just a symptom of a much deeper problem, and that is something that I want to get to. So hopefully I can do all of that in 15 minutes, so we'll see. If I talk too quickly, you'll know why. In any case, I want to start by saying that religious freedom is a fundamental American value that we all recognize and appreciate. That's why it's protected in the First Amendment of the Constitution. The Muslim bans, on the other hand, they slam the door on people because of how they look and how they pray. That's an attack on religious freedom and our Constitution and our shared American values. And it's meant to, and in fact has and continues to, divide us as Americans. We need to repeal and oppose these kinds of Muslim bans or any religious bans or other religious discrimination or religious animus that we can see in policies or laws, even in its most recent iteration, the Muslim ban 3.0. And I'll get to that shortly. But religious freedom is supposed to protect all of our faiths, and even people who choose no faith. We don't tell people how to pray, and we don't ban people because of their religion here in the United States of America. Muslim ban 3.0 is still a Muslim ban, and it violates our values, our shared American values, the core constitutional principles that make our country great, and it does not make us safer. That's a big point to keep in mind. Muslim ban 1.0, 2.0, or 3.0, none of them work to actually keep us safer or make us safer as Americans living here in the US of A. So people of faith in particular should be concerned about what they are seeing, this attack on religious freedom. And given the fact that the majority of people in this room raised their hand when they asked to whether you identify with a faith tradition, shows that the people in this room are really the very people who should be standing up and most vocal against any kind of attack on religious freedoms. Because that kind of attack really diminishes our core constitutional principle, and it might be Muslims who are on the receiving end of that discrimination today, but that can extend and affect other people as well. So that's why it's incumbent on us as people of faith in particular to be active and vocal at this time. And we as faith leaders also play a role because we can talk about our moral values and really how this is about our moral values. And people, in fact, listen to faith leaders as much as they do to politicians and other leaders. So faith leaders really have a voice to play, a gap to fill right now in addressing what is happening in our country. And then when we get to the human impact of these Muslim bans. We heard a little bit from Amy about some of those stories. And I will say that, I'm with the Muslim Association of Puget Sound, which is the largest mosque in the state of Washington. We serve over 5,500 families in our congregation. So it's very large. We have a very diverse congregation covering 50 different countries, covering all kinds of different political views, class, everything else. So it's very diverse. And I will tell you, the general sentiment after Muslim Ban 1.0 was one of overwhelming fear and anxiety. Everybody I would talk to was concerned. And it didn't matter if they were from one of the countries that was named in the ban. It didn't matter if they were refugees, immigrants, green card holders, US citizens. None of that mattered. Everybody was scared and concerned. And everybody was also impacted. And what I mean by that is the fact that you were a green card holder did not protect you from the discrimination and the potential attacks, and also the being screened at airports more, being stopped at airports, being detained and not allowed to continue on at airports. This was happening to all people, even US citizens. US citizens were having something done to them that I actually don't think there was enough information or media representation of this. But US citizens who were Muslim were stopped at airports and asked religious questions. They were specifically asked, what is your religion? Do you pray 5 times a day? Do you, like these kinds, do you read the Quran? Do you believe in the Quran? These kinds of questions that are so fundamentally against what our country stands for. Fundamentally against our core constitutional value of religious freedom. This kind of religious animus and targeting is what was happening. And that's why everybody in the community was concerned. And beyond the Muslim community, you had people in other communities. Amy mentioned the Christian man as well. You had other people who were also being directly impacted and affected by this. I myself, like Amy, I traveled one time right after the Muslim ban, and I was concerned myself. And like Amy, for the first time for domestic travel, I took my passport with me. And I canceled some other flights because I was myself concerned. And anybody who came to me as an attorney and said, hey, what do? I told them, make sure you talk to another lawyer, not me, because I wasn't practicing. But I said that my recommendation is that unless you have to, do not travel right now. There were people who changed their plans to visit family, their work trips, and even their religious trips because of the bans that were happening at that time. And people who were supposed to be united with their families, people who had people show up at the airport, here at SeaTac Airport. There were people who were within feet of their loved one that they may have not seen for years even. They were kept separate. They were not allowed to unify. They were not allowed to welcome their relatives home. They were not allowed to do that. Some of those people were sent back to different countries. Fortunately, after the judge's orders and everything, some of those people were able to come back, thank God. But at the same time, there were people that were directly impacted. There was one woman whose husband, she could see sort of where he's at, but could not give her husband a welcome hello or a hug or a kiss or anything else. There were people who were separated from their children, who could not have their children come join them here. There was an infant that I think made national news who was here for health-saving surgery, and that infant was not allowed to come in. This is the kind of cruelty that we saw, the kind of separation of families, and really sort of like cruel behavior as a result of this this policy that wasn't legal, but this executive order that we saw. But one of the things, like Amy, that I saw that was so beautiful was the outpouring of community support, the outpouring of outrage that people had because this violates our common shared American values, because this goes out and attacks us at the core. So people showing up at the airport in support and speaking out against this horrible, unconstitutional, un-American, and immoral ban that was happening at the time. And I worked with the Attorney General's office in trying to identify cases of people who had been affected to write declarations to challenge this ban, both 1.0, 2.0, and now 3.0. And what I heard through that process of trying to get stories from people who had been impacted is that so many people were impacted, but many of them, as Amy recognized, were so scared, were too scared to even be willing to publicly share their story, were too scared to speak to media, were too scared to speak to the Attorney General's office or submit a declaration describing the impact that they had here in Washington State to be able to survive any kind of standing challenge that the government was certain to be bringing to any lawsuit by Washington State. And in fact, according to the Seattle Times, over 21,000 Washington residents are from the countries that have been directly identified. So there was a large capacity for direct impact here in Washington State. And we felt it at schools, people who were in school and universities. We felt it with the business world, with places like Boeing or Amazon that had employees from these different states. We felt it in sort of the economy. We felt it in our culture and sort of the scholars, visiting professors, all kinds of impacts, even here in Washington State. And I'll say one story about this one woman, Juwaya, who was separated from her husband and child who had been born in Somalia. And she was fighting to bring her 7-year-old son over here. And that was a struggle that she was going through after first one and second ban happened. And even now with Muslim Ban 3.0, the story that I'll share about this one real quick is a U.S. citizen, a gentleman by the name of Ethan. I'll just give his first name. He's a U.S. citizen who was born in rural Idaho, and he's now living in Seattle and works in the tech field and has his own business. And in 2015, he traveled to Istanbul. He traveled abroad and fell in love with a woman abroad that he was traveling, and she was also traveling there. Well, she was a resident of Iran. So because she was an Iranian resident, they were not able to sort of connect. You know, for the past 2 years, they've been talking on the phone every single day, he described. They've traveled to different places, different cities around the world, outside of America, in order to be able to be with each other, in order to have some time together. And he proposed to her as well during one of these trips. But they cannot come back together and be here together at home. They decided to marry earlier this year, and they started the paperwork process, the whole visa process. But in light of Muslim Ban 3.0, they are now separated, and they don't know what the future holds for them, despite their love and their desire to be together. Now, these are the kinds of impact stories, and there are so many of these kinds of stories. You can read some of those in the declaration that I think was added, the list of exhibits. A whole bunch of different people submitted declarations, and I give a lot of props to them for having the bravery, the courage to come out and share their stories at a time when they can be potentially face some the challenges or difficulty either by the government or reputational harm by others. So they are putting themselves out there to do this. So I give a lot of credit to them, and I hope you check out some of those stories to really understand the true human impact. But I also want to talk about something else, and that is that this Muslim travel ban, this is just a sort of another manifestation of a symptom. It is not the root problem. The root problem really is Islamophobia, xenophobia, racism. That's really what's at the core that's driving these kinds of policies. And the current president does sort of use scapegoating and fear-mongering as a way to sort of win political points. Now, I also have to add that it's not just the current president. It's not just Trump. It's very easy for people right now to point the finger at Trump and Trump alone and say he's the cause of all this that we're seeing. But in fact, this Islamophobia has been continuing, has happened before Trump ever came into the picture and extends well beyond him. In fact, even under President Obama, we had certain policies and actions and expansion of certain programs that were also very Islamophobic. Whether it was the NSEERS program, which was the National Security Registration Entry and Exit System, which in fact registered hundreds of thousands of Muslims and deported many as well. And that happened was expanded under Obama, and he ended it right before he left office. But this was a surveillance system, a registration system. A lot of people say, oh, I would never support a Muslim registry. Well, we've already had a Muslim registry, right? So I really want to be clear that this is not an attack just on, one party or one person or anything else. It goes well beyond that. And in fact, what's really disturbing right now is that we have a whole industry that profits off of and promotes fear of Muslims, misinformation, lies, and conspiracy theories about Muslims as a way to further their political agenda or their profit motives. And I have a chart here that I hope you'll check out that names some of the groups that are involved in this sort of, Islamophobia industry. And this shows how in sort of 5 years alone, they had access to over $205 million to spread sort of lies and misinformation and build this kind of fear of Muslims and Islam that we are seeing in our country. And this industry has affected other laws and policies as well. So again, this goes well beyond just Muslim bans. We have this whole movement against Sharia that we have seen. And Sharia simply means Islamic teachings. So if somebody tells me they're against Sharia, you're basically telling me you're against my freedom to exercise and practice my religion in America, which is not only anti-Muslim and anti-Islam, but it's unconstitutional and un-American as well. And I would even argue immoral. So those are the kinds of things that we are seeing. And there's this industry that was actually promoting these bills through legislation of different states throughout our nation. When they were promoting these anti-Sharia bills or anti-Muslim bills, they were, in fact, the guy who was behind drafting the bills for most of these states that we saw, he even admitted that he didn't care if the bill was passed or not. And in some states, over 10 states did pass the bills. Many other states, including Washington, did not pass them, thank God. But in any case, he said he didn't care if they were passed or not, because it wasn't really the bill itself was not really what was at issue. What he was trying to do is get people to start talking about this and start spreading fear among our sort of fellow Americans. And at a time when the majority of our fellow Americans do not personally know a Muslim and do not know much about Islam, it's really easy to spread misinformation and lies and promote this kind of fear narrative that we are seeing happening all around us. So this is a lot of what is happening. And I just want to end by saying that the hate crimes that we've seen against Muslims are at our nation's unprecedented levels, highest levels. Even in 2017 alone, we've seen a 91% increase in the first half of 2017, according to CARE. In 2016, we saw over a 40% increase, according to CARE. And in 2015, we saw a 67% increase of hate crimes, according to the FBI. And the impact on students and children in schools, the bullying and discrimination is what really bothers me. That's the part that really breaks my heart. And what's disturbing is 25%, 1 out of 4 instances of Muslim kids being harassed or bullied in schools is at the hands of their teachers or school administrators. So this is really a problem. And what I would just close on is saying, please take a call to action. I have some action sheets and some little booklets on challenging Islamophobia, so you can actually get to the root instead of just the symptoms. And there are events happening, especially this week, because October 18th is the effective date of Muslim Ban 3.0. And on October 18th, we're having a rally in downtown Seattle. And there's also 2 talks that I'm giving with Pastor Terry Kylo on combating Islamophobia and standing with our Muslim neighbors. This is the Faith Over Fear Roadshow that we're doing, 10 a.m. at Plymouth Church and 7 p.m. at St. Andrew's Episcopal Church. So I really hope you guys will join us for one or both of those and learn more about this industry that is really seeking to divide all of us as Americans and help us all stand together, united against this fear narrative and this divisiveness, and really show that love and our faith is far greater than hate and fear. Thank you.
Who knows? I mean, the youngest person can't even operate PowerPoint. What is going on here? Thank you for all the comments and the panelists. I really appreciate that, and all the sponsors for being willing to host this event. It's my goal, many goals. One is to be short. I know that's the famous last words for lawyers. Another key thing I know is for lawyers is to be successful in any talk is to set the standard as low as possible for yourself. So that's what I'm going to do. My goal is just to kind of really situate the Arlene's Flowers case in kind of the national scene and kind of just explain some arguments. That way you can all go back on Twitter or make anonymous comments more effectively, and debate with your friends and have a sense of what's going on. So you probably, let me get this little, well, try again. There we go. All right, so you probably all, and just a little bit about myself. My name is Jonathan Scruggs. I work for Alliance Defending Freedom. We probably are, I would say, the lead people in most of these lawsuits you've heard about, Jack Phillips, Masterpiece Cake Shop, Arlene's Flowers. Maybe even bring a bit of a unique perspective because we represent people of faith and sue the government, but we also represent the government sometimes against Establishment Clause challenges. But I'm really going to focus on Arlene's, like I said, just kind of situate that and explain a couple of basic arguments. So as everyone might know, I just want to, the basic facts here. This is Baronelle Stutzman. She runs Arlene's Flowers, which is a floral shop out in Richland, Virginia. She served, there's a same-sex couple that she served for 9 years, made various floral arrangements for them, whether it be for Valentine's Day, their anniversary. But one day in 2013, Mr. Ingersoll, which was one person of the same-sex couple, comes in, asks for, hey, can you make floral arrangements for my same-sex wedding? And Baronelle basically, I think the exact quote is, basically says, I love you dearly, I think you're a wonderful person, but my religion doesn't allow me to do this. And then Baronelle referred Mr. Ingersoll to some other floral shops. Over time, that kind of got out on the internet, as everything seems to do. The Attorney General saw that news report and then sued Baronelle for violating the Wisconsin law against discrimination. That was litigated up to the Wisconsin Supreme Court. Baronelle lost. We've now sought cert, a cert petition at the U.S. Supreme Court, which is now pending. Let's see here. Woo, go forward. So that's Baronelle at the Washington Supreme Court. My favorite part about this picture is the person in the middle, the man in the middle of the jacket that looks very sad to be there. Don't worry, that's our security person, Eddie. I make fun of him all the time. He's not like a plant. But, there's a fair amount of support at the Washington Supreme Court for Baronelle. So Baronelle is, in some sense, now hitched her wagon to Jack Phillips. This is the baker that's mentioned earlier, cake designer that's mentioned earlier from Colorado. Basic same set of facts. A same-sex couple comes in and asks, can you make a wedding cake for my wedding? He politely declines, says, I'll sell you anything else in the shop. I just can't do that. And then he's later sued by the Colorado Human Rights Commission. And there he is with his cake, kind of doing some cake there. It's one of the cakes he designs. One of the great jobs in my job is I get to learn about cake making and artistry. I can tell you all about those things. If you've read our merits brief, we put a lot of that in there that's really interesting. So those are the kind of the cases you've heard about. Let me just fly through some other interesting things you might not have. That is Blaine Adamson. He is a print shop owner in Kentucky. He was approached by a LGBT advocacy group and asked to make T-shirts for a gay pride festival. He, again, politely declined, referred them to another print shop, and was subsequently sued by the Lexington Human Rights Commission. And that's a case that we've actually won up to the Kentucky Appellate Court. The opposing side is now appealing that to the Kentucky Supreme Court. And I go through these cases just to show that it's actually not really about cakes and flowers. That's probably what you see in the news, but it really goes broader than that. This is Joanna Duca and Brianna Koski. They're artists. They own an art studio. One's a calligrapher and one's a painter. Same, again, set of facts. They're challenging the law, seeking kind of their right to engage in artistic freedom. There is Joanna doing her calligraphy on the First Amendment. Again, I realize I have really bad handwriting compared to this. Like all lawyers, it's just amazing what she can do. It's pretty spectacular. And there's some of their art there. They do wedding invitations, signs, paintings, things along those lines. That is Lori Smith. She's a website designer. She's in Colorado. After hearing about Jack Phillips' case, she brought a lawsuit against the same law that Jack is challenging. That is Carl and Angel Larson. They own a film production studio in Minnesota. So they want to have the right to control what films they make and don't make. And finally, this is Amy Lawson. She is a photographer and a blogger in Wisconsin. And another case that we've won, saying that she wants the right to control what weddings she photographs, and not just weddings, but also other events, and what she blogs about. So I go through that again. I'll just go back here. I go through that again just to show it's not about just cakes and flowers. It's a wide variety of issues. And there's a common kind of fact patterns that I like to emphasize. All these clients are involved in expressive businesses, is what we call it, or creative businesses. So they're not just making hamburgers or renting hotel rooms, but they're promoting messages. That's what their job is. All these clients serve everyone regardless of status. Barronelle is probably the best example of that. She served Kurt and Rob for 9 years. She just can't promote certain messages that she disagrees with. So this is quite far afield of something like the Jim Crow era, where people were being excluded for who they are. For all these clients, it's not about who comes in the door, it's about what they're asked to promote, what message they're asked to promote, which is a key distinction, I think, that's sometimes often lost. And along those lines, all these clients are selective in what messages they promote. If you get to know kind of artists in this field, they all are very particular. They're not like lawyers. We accept everything, every project that comes in the door, maybe. But artists are very selective. So they, for example, Joanna and Brianna won't do anything that promotes a strip club. For example, won't do business cards that promotes a strip club because they view that as sexist and denigrating women. Blaine actually was requested to make a T-shirt that denigrated people from the LGBT community, and he refused because he didn't want that to promote that. Again, it's not about status, it's about message. All these cases involved, which was mentioned before, state or local public accommodation laws. These laws vary in their definition of what comes under the law. It varies in what defined as public accommodation. Some are very broad, some are very narrow. And you might be surprised to know that the ones in Seattle is very broad. It, for example, bans discrimination based off of political beliefs. And that's also, I think the broadest one I've seen is in the city of Madison that has 20 protected classifications, ranging everything from student status, again, to political belief discrimination. And finally, I'd like to note that all these cases involve clients who are really put to a difficult task. I mean, these laws have severe penalties. Many of them are criminal penalties, 90 days in jail, 6 months in jail. Some have extreme fines. I think Barronelle's example is a good situation, a good example of that. In her scenario, she was sued and is being sued not just in her capacity as a business, she has an S corporation, but also her personal capacity. So she's facing millions of dollars of attorney's fees that goes against her personally. That means she's going to lose her business, her home potentially, things along those lines. So these people are in a tough spot, right? Because in their view, according to their faith tradition, they cannot promote a belief that they disagree with. Do they leave the industry? Do they violate the law? What do they do? It's a difficult scenario. The common claims in these cases, I think was mentioned before, a compelled speech claim. The government can't compel people to express messages they disagree with. Often a RFRA type claim in the state of Washington. It's the free exercise clause in the state of Washington is analyzed in a RFRA type analysis. Sometimes it's a statutory claim in other states. But overall, the way I like to think about it, explain the basic argument, this is the way I kind of like to explain the basic argument, is these cases aren't about same-sex marriage. They're about the right, again, to promote, the right to prevent the government from forcing you to promote or participate in, to promote a message you disagree with and to participate in a religious ceremony you disagree with. And the example I like to give is imagine a lesbian web designer is asked by a religious person or religious group to create a website that criticizes same-sex marriage. Should that web designer be forced to do that? And I think most people, commonsensically, would say no, that no law should force that web designer to promote that message he disagrees with. And all we're saying in our cases is basically the same rule should apply. That people shouldn't be forced to violate their conscience in that manner. So that is kind of the general argument, and I think that example is on all fours because that involves a scenario where a person comes in from a protected status. Is that discrimination? I don't think so. As noted before, I think it's a helpful distinction. There is a vast difference between discriminating based off of who you are versus choosing what messages you promote. That is a key distinction that underlies all these cases And it's one the Supreme Court has recognized in a case involving it's called Hurley. It involved parade organizers. The Supreme Court unanimously said that a public accommodation law couldn't compel parade organizers to include a gay advocacy group. And in so doing, the Supreme Court said, well, they allow gay people to march in the parade, they just can't allow them to promote the messages in the parade they disagree with. Our clients are basically saying the exact same thing. And so the outcomes of these cases, as I mentioned, are mixed. Arlene's Flowers obviously came out against Barronell. It's on cert. Jack Phillips' case is pending at the Supreme Court with oral arguments on December 5th, which are obviously going to have a huge impact about where these cases go. I finally want to conclude by just kind of laying out some general litigation challenges. There are a lot of litigators in the room, so maybe this could resonate with some of my panelists. But these are hot button issues, which makes these cases a challenge. They're often debated on Twitter. You might be surprised to know that Twitter sometimes loses the nuance that these cases need to involve. You see, you're either you're for discrimination or you're against religion. I like to think that there's, again, a bit more nuance here in reading the briefs that are useful for that matter. That there's often an element of it's difficult to explain religious beliefs to other people. One common theme that we've heard is, just bake the cake. It's not a big deal. To me, that's kind of reminiscent of Barnett and Woolley. Those involved Jehovah's Witnesses. Many people didn't understand, hey, why don't you just salute the flag? Why don't you just put the, go with the license plate on your car? It's no big deal. Those Jehovah's Witnesses viewed that as a big deal. And so in many ways, that is a challenge for us. The burden on our clients is obviously big in these kind of high media events. If you Google Telescope Media Group or any of our clients, you probably could see some nasty comments about them. It's a struggle to walk with our clients through that path of how to handle that. Explaining complex constitutional issues in a simple way is, a struggle with a lot of these cases that we've mentioned. And finally, just kind of the duration. Again, you probably will be surprised to know these cases often don't settle. They go a long way. I kind of make it akin to they're like my children. You kind of grow up with them. They last 10 years or more. And so we will see how this case goes with Jack Phillips and Master Keith's Case Shop, which will hopefully provide a fair amount of guidance to see what happens in Washington, what happens with Arlene's Flowers, and what happens across the country. Thank you all so much.
I'd originally planned for the panel to discuss, but since we only have about 15 minutes or so, I think it's better to actually open it up for your questions. We've been a little light on your questions, a little heavy on the conversation on this end. So I'd like to open it up to questions from the audience. And just address who your question or the speakers that you want to answer your questions. Others may leap in as well, but thanks.
Well, thank you all. It was wonderful panel presentation. My question's for Amy. I want to commend you for your work in challenging the ban, and also for what you've done and the state of Washington have done in kind of flushing out animus, anti-religious animus that might underlie something that might appear to be something else. The question I have, though, it also goes in conjunction with your work with the ACLU, is I do a lot of work defending school choice programs that empower parents to choose the schools, public, private, religious, non-religious, that are best for their children. And the ACLU in those cases, inevitably when a program passes, will run to court and challenge the program, which is perfectly permissible under the Establishment Clause, but they'll challenge them under state constitutional Blaine amendments. These are provisions that are rooted in the 19th century anti-Catholic bigotry. And when we point that out, and we discuss the implications of applying this vestige of bigotry today to deny parents choice in education, the ACLU will often tell us, or tell the court, that history is irrelevant, that the discussion of the passage of the Blaine Amendments is irrelevant and that, or you don't need to look at it, or that it's inconclusive, we can't really discern what was in the mind of the people who passed these things. And so I just wonder if, do you know how the ACLU reconciles its willingness to look at evidence of animus in one setting but not in the other?
It's an excellent question. I'm a cooperating attorney with the ACLU just on this one case, and I have no visibility or insight. I haven't worked on any of those cases, so I have zero answer for you. But I do. It's an interesting question, and I acknowledge that. But unfortunately, I have no information. Yeah.
Thank you.
Yes. One of my great students. Thank you.
Thank you. So I have a question for both of you, and it comes from Scruggs on freedom of speech and where your positions and beliefs. So the question goes like this. Let's say that someone comes to one of these persons and they are, for example, Muslims, and they say, I want a banner that say, I agree with the Muslim ban. And you say, no, I don't want to make it. And then these people sue your client, saying, well, you're discriminating against my beliefs, you are discriminating against me, or even my belief, my position, or my conscience. Well, how would you counteract this position, saying that, like his cases, but under your situations? Do I make myself clear?
Yes. Do you want to go? I don't know. Well, obviously you gave me limited facts, and hard to make broad pronouncements on limited facts. But did you?
Let's say it's the same facts of this case, but a Muslim ban. The same facts.
Okay. So someone's being asked to make a sign for a position that they feel is against their own religion. Well, the Washington law against discrimination, which is what the state sued the florist in Arlene's Flowers under, would say that, and does say, and the Washington Supreme Court says that when you engage in commerce in the state of Washington, you subject yourself to all sorts of regulations, and there are all sorts of rules and policies that you need to follow. And you, for the privilege of engaging in the economy and for the privilege of offering your services in the state of Washington, you in turn may not discriminate against others. And the difference here, so when for Arlene's Flowers, when she turned down the request to do flowers for that wedding, the state sued, and under the Washington law against discrimination, her defense, as I understand it, and I did not work on this case, but I've read the decision. Her defense was, no, I was expressing my First Amendment right to artistic expression, and I couldn't engage in this art for this particular wedding. And the Supreme Court of Washington affirmed the lower court, and they both found similarly and said, this is not artistic expression. Your provision of flowers for this wedding is not artistic expression. And so they found that that she had violated the Washington law against discrimination. Now, under your scenario, if, let's say, the Muslim printmaker turns down the request to make a sign that says something anti-Muslim, if the state were to sue to enforce the Washington law against discrimination, you would, I presume, and the printmaker said, no, I couldn't do it because I don't agree with that message, the court would analyze whether that defense had merit, and whether it's conceivable that under those facts that would be a permissible reason to turn down an engagement. I don't know, but I don't necessarily conclude from Arlene's Flowers that the outcome that you posit would be the outcome in that case, because the nature of the activity is different. And I think that's what's interesting about the cake case, is that the effort on describing the making of a cake as true artistry, and trying to, I think, differentiate it from the provision of flowers, and trying to make it more about art than simply providing a good. So that's where these cases, I think, are really heading. It's going to fall on some spectrum between denial of service versus something that's actually some sort of expression or endorsing some particular opinion.
So I'm interested, is this on? Doesn't seem like it. So I'm interested in.
You stand, maybe go over to the other one,
I'll
please.
just yell. I'm interested
Okay.
in Jonathan's response to that same question. And then also, this is just, I'm showing my ignorance here, but why wasn't Arlene's Flowers a violation of free exercise case? Why is it a freedom of expression?
Sure. Well, to answer the second question first, it's both. We brought free exercise claims under the federal constitution, but also the state constitution, which, like I said, operates under kind of a pre-Smith RFRA regime. The court said, acknowledged that the law created a substantial burden on our client's religious beliefs, or, like I said, assumed it, but went on to hold that there's a compelling interest in compelling her to promote that message or along those lines. Your first, in kind of response to the first point, I'm glad to know the ACLU is on board with most of our cases that I put up. As I noted, it's, in, for example, the brush and nib case, the ACLU of Arizona filed an amicus brief against us, saying that essentially the court could, the state or the city could compel our client to write words. An example in that scenario is our clients write signs for weddings. And often one example they do is write a sign with a Bible verse on it from Mark that basically says, what God has joined together, no man to separate. And the city has taken the position that the government could compel our clients to write that sign for a same-sex marriage. So I would disagree with the analysis put forth about what Arlene's did. My read of the Supreme Court is it didn't analyze whether the floral arrangements were artistic expression. It focused instead not on the final product, but on whether the decline was communicated a message, and went straight to a compelled or an expressive conduct analysis. We view that as incorrect. It's much like in Hurley, the court in Hurley didn't ask, well, did the organizers decline to let people in the parade, did that express a message? It asked whether the parade itself, the final expressive product, conveyed a message. That's what we view as the proper analysis to take. And we think that analysis would apply to all these cases and would protect all these cases under the free speech doctrine. But, if we want to get to the point where we're debating about what is free speech or not, I'm glad to have that debate. I think everyone would acknowledge that photography, words, film, all those things would be considered protected under the First Amendment.
Other questions?
Getting back to the Muslim, this is on. I'm just curious if there is any precedent that you're aware of for considering the language of candidates on the campaign trail to be relevant for sort of the statutory analysis, or in this case, a legal analysis of the legitimacy of an executive order. I think most people would agree that the language used on the campaign by Mr. Trump did express animus. But to what extent did the lower courts rely on this campaign rhetoric? And campaign rhetoric obviously can be very heated, and most people don't think of it as legal communications or legislative communications. So really, I'd love to know your opinions, both of you, but also whether there is any court precedent for taking that kind of campaign rhetoric and saying, we're going to evaluate the constitutionality of this action by the executive in light of their campaign rhetoric.
Yeah.
Sure. Thank you for the question. I think it was the Hawaii court that in fact did identify specifically the rhetoric of Trump on the campaign trail as evidence of the religious animus. And I believe they actually set forth the specific language or described the language as well. So that, and I don't know if they specifically cited any precedent in doing so, or if they just put it in there and now have created some precedent for us to follow. But certainly it informed the intent behind it, because that's what the courts were looking at was there religious animus? And part of that is what is the intent of this specific executive order that they are evaluating?
And do you think that that will, that reasoning will prevail at the Supreme Court? Or what, I guess, how do you evaluate the likelihood of the court letting that sort of evidence of animus in?
Yeah, it's a super interesting question, because basically there are First Amendment issues on all sides of this case, right? It's the you've got my client and the Archdiocese of Seattle who's suing to stop the ban. You've got Muslims who are impacted by the ban. You've got under Executive Order 1 some Christian refugees who are being preferred, and then in the attempts to dismantle the ban, you're looking at the campaign statements and what's Mr. Trump's free speech right to say what he wants on the campaign trail, and when does that carry over into office? So there's just so many rich issues. I believe you're right, Aneelah, that the judge in Hawaii, the district court judge in Hawaii, cited in his order examples of the campaign statements. But on the specific question you ask, the Ninth Circuit argument in Hawaii was, I was at the argument, and the judges were very interested in this question and asked questions about it. And they didn't want to get into the details of what had been said on the campaign. They didn't really want things being read out loud, but they acknowledged that statements had been made that could easily be characterized one way. And there's no precedent for it. There's no precedent that was cited by either side for campaign statements being held against it. And I think it's because there's no precedent for this man, for Donald Trump. There's no precedent for this action that was taken. And ultimately, the Ninth Circuit, and there was a question to that effect, and both sides said there's no case law on this. But the Ninth Circuit ultimately held that the executive EO2 at that point was unlawful under the Immigration and Naturalization Act, INA. So the Ninth Circuit did not address the constitutional issues. It skirted those. The Fourth Circuit had ruled that the EO2 was unconstitutional, that violated the First Amendment. But the Ninth Circuit did not reach the constitutional grounds. And the Supreme Court was to hear argument this week, but dismissed the case as moot in light of EO3. So, and the Supreme Court also has vacated the Fourth Circuit's opinion, just by per curiam order of the court without any analysis, has vacated the Fourth Circuit's opinion. So the Ninth Circuit's opinion has not been vacated. One wonders whether that might happen. The state of Washington just moved to re-engage its litigation here before Judge Rohrback, and there's going to be, and the judge allowed the state in an order yesterday to lift the stay, amend its complaint, and proceed with another temporary restraining order. And last night, Judge Rohrback set oral argument on that for the last week of October.
So I should probably wrap up this panel. So can you join me in thanking Amy and Aneelah and Jonathan?